Then it says, the court takes a bite out of the merits for the order of August 4th, 1973, bars the Court of Appeals from reinstating the judgment of the District Court until and unless this court acts, as the order states, that the order of the District Court is, quote, hereby stayed pending further order by this court, end quote. Footnote 2. The Supreme Court of the United States shall consist of a Chief Justice of the United States and 8 Associate Justices, any 6 of whom shall constitute a quorum. 28 U.S.C. Section 1. Footnote 3. The statutes authorizing individual justices of this court to affirmatively grant applications for such actions do not authorize them to rescind affirmative action taken by another justice. See, e.g., 28 U.S.C. Section 2101F, stays of mandate, 28 U.S.C. Section 2241A, writs of habeas corpus, 18 U.S.C. Section 3141 and Federal Rules of Criminal Procedure 46A2, granting of bail. Footnote 4. This requirement of collegial action is confirmed by the rules of this court and by this court's prior decisions and practices. Rules 50 and 51 govern the in-chambers practices of the court. Rule 50(5) provides that when one justice denies an application made to him, the party who has made the unsuccessful application may renew it to any other justice. It was pursuant to this rule that application for the stay in this case was made to me. But neither Rule 50 nor Rule 51 authorizes a party, once a stay has been granted, to contest that action before another individual justice. The court has previously deemed it necessary and proper to meet together in special term before stays granted by an individual justice out of term could be overturned. In Rosenberg v. United States, 346 U.S. 273, the full court felt constrained to consider its power to vacate a stay issued by an individual justice, finally resting that power on the court's position as a body, as final interpreter of the law. We turn next to consideration of our power to decide in this proceeding, the question preserved by the stay. It is true that the full court has made no practice of vacating stays issued by single justices, although it has entertained motions for such relief. But reference to this practice does not prove the non-existence of the power. It only demonstrates that the circumstances must be unusual before the court, in its discretion, will exercise its power. Quote, the power which we exercise in this case derives from this court's role as the final forum to render the ultimate answer to the question, which was preserved by the stay. Then there's another quote. The reasons for refusing as a matter of practice to vacate stays issued by single justices are obvious enough. Ordinarily, the stays of individual justices should stand until the grounds upon which they have issued can be reviewed through regular appellate processes. Another quote. In this case, however, we deemed it proper and necessary to convene the court to consider the Attorney General's urgent application. Finally, it is our procedure during a term of court to take an application that has already been denied or acted upon by one of the justices to the entire court upon an application made by the opposing side, so that the entire court can act and thus prevent shopping around. That course is not possible during recess, when the justices are scattered around the country and throughout the world. Therefore, it has been my practice, if I grant a stay during recess, to make that stay effective only until the court convenes in October. This course could not be followed in the instant case because, after August 15, 1973, the case will be moot.